Just to say before we go into public session, we normally stay going to restrained public session. So our proposal this morning is that we don't take a break, that we stay going and try and conclude about 11:30, if that's okay with members. Mark, you only have to arrive. Are you okay with that? Okay.
Agreed.
Agreed. Witnesses are okay with it too, I take. Okay. Okay, thanks. So we have a quorum, so we're going to call the meeting to order, and the committee is now in public session, so you're all very welcome. I want to remind all those in attendance to ensure that your mobile phones are switched off or in silent mode. Before we start, I wish to explain some limitations to parliamentary privilege and the practices of the Houses as regards references you may make to other persons in your evidence. The evidence of witnesses physically present or who gave evidence within the parliamentary precincts is protected pursuant to both Constitution and statute by absolute privilege. As you're within the precincts of Leinster House, you're protected by absolute privilege in respect to the presentations you make to the committee. This means you have an absolute defence against any action, defamation action, or anything for anything that you say at the meeting. However, you're expected not to abuse. You're expected not to abuse that privilege. It is my duty as Collier Law to ensure that it's not abused. Therefore, your statements are potentially defamatory in relation to an identifiable person or entity. You will be directed to discontinue your remarks, and it's imperative that you comply. Members are reminded of the provision of Standing Order 218 that the committee shall refrain from inquiring into the merits of a policy or policy of government or a minister of the government or the merits of the objective of such policies. Members are also reminded of long-standing parliamentary practice that shall not comment on, criticise or make charges against a person outside the Houses or an official leader by name or in such a way as to make him or her identifiable. So this morning we're joined by the Controller and Auditor General, Seamus McCarthy, as a permanent witness to this committee, and he's accompanied by Mr Mark Brady, Director Deputy of Audit at the Office of the Controller and Auditor General. This morning we're engaging with the Irish Horseracing Regulatory Board Financial Statements 2021, Irish Horseracing Regulatory Board, and we're joined by the following representatives from IHRB: Mr Darragh O'Loughlin, CEO, Mr Niall Cronin, Head of Communications Strategy, and we're also joined by the following representatives of Horseracing Ireland: Ms Suzanne Eade, Chief Executive, Mr Jason Morris, Director of Racing and Strategic Projects. We're also joined by the following officials from the Department of Agriculture, Food and Marine: Mr Gordon Conroy, Assistant Secretary General, Mr Owen Ryan, Senior Superintending Veterinary Inspector, and Ms Louise McAlevey, Assistant Principal Officer. So to begin with, I'm going to call on the Controller and Auditor General for the opening statement.
The Irish Horseracing Regulatory Board is a company limited by guarantee. The company was established by the Turf Club and the Irish National Hunt Steeplechase Committee with effect from 1 January 2018 for the purpose of carrying out the regulatory and licensing functions for Irish horse racing as provided for in the Horseracing Ireland Act 2016. The members of the board are appointed by the Turf Club and the Steeplechase Committee. The board has a number of statutory functions under the Horse Racing Industry Act 1994 as amended, including responsibility for making and enforcing of the rules of racing and decisions on handicapping for races, provision of integrity services for horse racing, including doping control and forensic testing, and licensing of all participants in horse racing in Ireland. The board is funded mainly by grants from Horse Racing Ireland and licence fees received from trainers and jockeys collected on the board's behalf by Horse Racing Ireland. The budget prepared by the board is submitted to and agreed annually with Horse Racing Ireland. The board received funding of €10.2 million from Horse Racing Ireland in 2021. This accounted for 88% of its income in the year. The board also received €1.4 million in licence fee income. The board generated a small profit in the year, having expended €7.8 million on integrity services and €3.9 million on administrative expenses. The 2021 financial statements received a clear audit opinion. However, without qualifying that opinion, my report drew attention to two matters. First, the Code of Practice for the Governance of State Bodies issued by the Minister for Public Expenditure and Reform requires public bodies to disclose certain information in their annual financial statements. This includes details of the remuneration paid to the Chief Officer of the public body and staff remuneration by salary bands. This is standard practice among the public bodies I audit, and I draw attention to any material non-compliance that I find. The Irish Horseracing Regulatory Board was granted an exemption by the Minister for Agriculture, Food and the Marine, which meant that it did not have to make the salary disclosures in the 2018 to 2020 financial statements. In May 2022, the Minister wrote to the Board requesting that its 2021 and subsequent financial statements should disclose both the normal salary band information and the remuneration of the Chief Executive, to include all short-term benefits and any termination benefits if relevant. As outlined in Note 10, the Board has not complied with the Minister's request to make the disclosures in the 2021 financial statements and therefore is not compliant with the Code of Practice. The second matter is that an early retirement and voluntary redundancy scheme was made available to the Board staff on the 11th of May 2021. Subsequently, the then Chief Executive applied for and was granted early retirement. A formal agreement was concluded with him on the 11th of June 2021, providing for his departure with effect from the 30th of September of that year. The terms of the agreement included a termination payment of €384,870. This exceeded by €141,880, or 58%, the amount payable to the Chief Executive if the scheme conditions advertised to staff had been applied. It was clearly stated that there would be no exceptions to the scheme conditions. The payment amount agreed with and paid to the Chief Executive was a significant exception to the early retirement scheme terms.
Thanks, Seamus. Mr. McLaughlin, very welcome. Can I have your opening statement? 5 minutes.
Chairman, members of the committee, on behalf of the Irish Horse Racing Regulatory Board, I want to thank the Chair and the members of the Public Accounts Committee for their invitation to appear. As the Chairman says, my name is Darragh O'Loughlin. I was appointed Chief Executive Officer of the IHRB in June of 2022. I'm joined by my colleague Niall Cronin, who is our Head of Communications and Strategy. The Irish Horse Racing Regulatory Board was established in 2018 by the Turf Club and the Irish National Hunt Steeplechase Committee to carry out the regulatory and licensing functions assigned to the racing regulatory body under the Horse Racing Ireland Act 2016. The mission of the Irish Horse Racing Regulatory Board is to ensure that the reputation of Irish horse racing and confidence in the sport are protected by robust and transparent regulatory practices implemented with integrity by a professional and progressive team. Under the legislation, the IHRB is solely and independently responsible for the making and enforcing of the rules of racing, and it operates under a service-level agreement with Horse Racing Ireland in relation to the provision of horse racing integrity services. The Horse Racing Ireland Act 2016 provides that HRI is responsible for guaranteeing funding to the IHRB to carry out its functions through an integrity services budget which is agreed annually. The IHRB is the internationally recognised body for Ireland racing in respect of its functions. It is a member of the International Federation of Horse Racing Authorities and is signatory to the International Agreement on Racing and Breeding, which provides the basis for international racing. Although not a statutory body, the IHRB abides by the underlying principles of good governance, accountability, transparency, probity, and a focus on the sustainable success of the organisation over the longer term, and aligns to the requirements of a non-commercial state body as set out in the Code of Practice for the Governance of State Bodies. The IHRB is governed by a board of 8 directors, 3 each nominated by the Turf Club and the INHSC, all of whom serve without remuneration, and, as of this year, 2 independent directors. The IHRB board gender ratio is 5:3 male to female. In addition, the IHRB has appointed an independent chairperson to its Audit and Risk Committee. Responsibility for day-to-day operational matters is vested in the senior management team led by myself as Chief Executive Officer. As we approach the end of the current strategic plan 2019 to 2023, the directors and management of the IHRB are currently engaged in extensive internal and external consultations with stakeholders across and outside the industry as part of the development of a renewed strategy for the coming years. Within the last 48 hours, in the course of preparing for this meeting, I became aware of a hitherto unknown issue that occurred in early 2022, which caused grave concern. I immediately brought it to the attention of the Chair of the Audit and Risk Committee and the Board of the IHRB, and the Board has commissioned a full review of the matter to be conducted by an independent firm. Additionally, the preliminary facts, as they are known, have been disclosed to the relevant bodies, including the Office of the Comptroller and Auditor General, Horseracing Ireland, and the Department of Agriculture, Food and the Marine. The committee will appreciate that I am not in a position to give any further details on the matter at this time, pending the outcome of the independent review. The IHRB is responsible for regulating Irish horse racing, including equine anti-doping control. Our key functions include making and enforcing the rules of racing, providing integrity services for horse racing, ensuring the provision of on-course integrity services by employing, monitoring and controlling the activities of horse racing officials, licensing all participants in horse racing in Ireland, making all decisions relating to doping control, forensic testing and handicapping, being responsible for the representation of Irish horse racing internationally in respect of our functions, and providing governance for point-to-point steeplechase and enforcing the Irish National Hunt steeplechase regulations. As a 32-county All-Ireland body, the IHRB carries out its functions through a team of 25 experienced administrative staff working from our offices in the Curragh and over 100 highly trained professional racing officials at race meetings across the island to ensure that the rules are properly observed and that the integrity of the sport is maintained. The IHRB also relies on a network of over 140 volunteer race day stewards and committee members who lend their professional expertise to ensure Irish horse racing adheres to the rules and is properly governed at all levels. In 2021, the IHRB presided over 395 race meetings and 54 point-to-point events, up from 332 race meetings and 68 point-to-points in 2020. We held 949 stewards' inquiries and 93 regulatory hearings, consisting of 56 referrals and 37 appeals. In 2021, the IHRB issued licences to 654 riders, 366 trainers and 217 restricted trainers, which were increases on the previous year when the equivalent licence numbers were 557 riders, 348 trainers and 192 restricted trainers. However, point-to-point handler permits declined to 566 from 574 in 2020. We also registered 3,614 stable staff in 2021, of whom 1,726 were full-time and 1,888 were part-time, an increase on the 3,444 registered in 2020. Licence fees paid by racing participants amounted to 1.032 million in 2021, representing 9% of IHRB revenue. Fees charged by the IHRB are reviewed on an ongoing basis to ensure they reflect the value of the licence without posing an unreasonable barrier to participation in the sport. Equine anti-doping is a top priority for the organisation, as it is for the sport, and the IHRB has no tolerance for any rule breaches in this regard. The IHRB's equine anti-doping strategy has evolved in recent years to operate on a sophisticated risk and intelligence basis backed by rigorous processes of investigation and follow-through in the event of an adverse analytical finding. As important as it is to take enough samples, it is also crucial to take the right sample from the right horse at the right time to maximise the likelihood of detecting prohibited substances if they are there, to deter those who might be tempted to cheat through doping, and to disrupt inappropriate activities. Our systems for tackling doping concerns continue to be strengthened, and the appointment by the Minister for Agriculture, Food and the Marine of 12 authorised officers was another welcome development. This allows IHRB veterinary officials to gain access to any thoroughbred in any location in the state at any time.
Can I just stop you at that point, Mr. Locke? Just members have the rest of the opening statement, and if members are happy enough, excuse me, we can proceed with the witnesses. Just that we're watching time. we have your statement and the other issues that are members happy enough to deal with it that way? We're not trying to be abrupt with you or anything like that.
I'm in your hands, Mr. Chairman.
And thanks for the open statement. Could I just ask you, just in relation to the change in the open statement, we did have Mr. Donal O'Shea, the Chief Financial Officer, on our list of invites, and I understand up to yesterday he was to be here. What happened there? Why isn't he here, Chief Financial Officer?
Our Chief Financial Officer is currently on a period of voluntary leave without prejudice to his position.
Since when?
Since yesterday.
Yesterday. And could I ask, and I know that you're going to be careful about giving details, but in relation to the hitherto unknown issue that emerged that gave rise to grave concern, I don't want you to go into detail, but just what area does it relate to? What matter? What subject matter is it?
I don't wish to say anything that could in any way prejudice the review that is going to take place.
Don't go into the details.
The review will be into the matter, which is financial in nature, and in all of the circumstances around the specific issue and the events that led up to it and that gave rise to those circumstances.
And is Mr. O'Shea's absence this morning relating to that? Does it relate to that?
I really don't wish to say anything that could prejudice the outcome of any review or investigation in the future.
Okay. Thanks. And just to welcome Ms. Caroline Ball here as well from the department that left you out of the list. You're very welcome again. So thanks for that and thanks for the opening statement. So to move on to the committee members then, the first committee member this morning is Deputy Catherine Murphy. 15 minutes, Deputy.
Thank you, and indeed I had very similar questions because it's very, very, very unusual for us to have a very significant late change to the opening statement, such as the one that you've given us, and obviously you have said that there is going to be an investigation. Who brought the issue to your attention?
The issue came to my attention in the course of preparing for today's meeting.
And when was it brought to your attention? Yesterday?
The issue first came to my attention on Tuesday morning.
Okay. Who brought it to your attention? Was it the Chief Financial Officer?
There are details that unfortunately I won't be able to provide today for fear of prejudicing any review or investigation that has yet to take place. All I can say, Deputy, is that while I was preparing for this meeting today, given that it relates to the 2021 financial statements, I was preparing by reviewing those statements and then subsequent events, so that after the post-balance sheet events, so as to better understand these statements to ensure that I could answer any reasonably anticipated questions here. In the course of that preparation, I became aware of an issue that had occurred in early 2022, so it doesn't form part of these financial statements, but which is a relevant matter potentially, and it related to governance around financial transactions. When I became aware of the issue, I immediately ended the preparatory meeting for this meeting today, and I made contact with the independent chair of our Audit and Risk Committee so as to report my concerns to him, and then, having reported my concerns to the chair of the Audit and Risk Committee, made contact with the chairman of the board of the IHRB to inform him of my concerns and took legal advice. We convened a meeting of the directors of the IHRB yesterday morning. So the board met and the board also took legal advice and the board made certain decisions. Immediately following the board meeting, I made contact with our colleagues in the Comptroller and Auditor General's office to advise them of all the facts that I had in my possession. After that, I made contact with Horseracing Ireland as our funding body. I spoke with the Chief Executive to again make her aware of all of the facts as I had them in my possession at that time. And following that, I made contact with senior officials in the Department of Agriculture, Food and the Marine to again step them through what had come to my attention and to give them all of the facts so that they could advise the Minister.
And
With the assistance of the Chief Executive of IHRB, we've identified an independent firm who doesn't currently do any work for the IHRB, who will be carrying out a review of all of the circumstances around the matter that I'm afraid, Mr. Chairman, I can't describe. The terms of reference of that review will be drafted with the assistance of our legal advisors, and I expect that it will be a very thorough and extensive review, at the end of which a full report will be published, which will be informative to all of us and will make clear at that stage what it is that unfortunately I'm not able to tell you today.
And what timeline can we expect that review to be conducted within?
I expect the review will take a number of months. It will be an extensive review.
Okay. Okay. I'm going to move on to some of the questions that I have for you, and I want to begin by dealing with the former CEO's early retirement or redundancy, or a combination of both. On the 11th of May 2021, the then CEO indicated that there would be an early retirement and redundancy scheme put in place. Exactly a month later, the CEO, the 11th of June, the CEO applied and was granted early retirement. There was a scheme set out, and it was to stay within the amounts set out. But there was 142,000, or 58% more than the amount payable if the scheme conditions had been applied as stated to the CEO. So the CEO benefited from 142,000 additional. And some of that money appears to have been made up by a grant or a loan from the Turf Club. Why would you receive a contribution from a private company to top up an individual who's not an employee of the Turf Club?
My understanding that the additional contribution from the Turf Club and the INHSC was a recognition of the retiring CEO's decades of service to horse racing across the island of Ireland and indeed internationally.
There was a scheme offered. This went above the scheme, above the terms, and then this is some sort of an additional payment that is separate from the IRHB that the Turf Club made.
The facts as you outlined them are correct.
And does that then have the benefit of not, having tax applied to it? What happens there, because this person was not an employee at the Turf Club? Is it a loan? Was it a grant?
It was in the form of a contribution from the Turf Club to the retiring CEO's retirement. The deputies raised a question relating to the taxation of the additional contribution, that part which was not made up of state funds. We had a review carried out by independent auditors earlier this year, so that I could be satisfied that the entire payment, both aspects of it, had been properly taxed, and I have been advised that because it was all processed through the normal payroll processes, it was taxed appropriately. Okay,
can I ask you, in terms of the open statement from the CNAG, you were granted an exemption by the Minister for Agriculture, which meant you didn't have to make the salary disclosures in 2018 and 2019. The Minister wrote to the board in 21, and subsequently financial statements disclosed both normal salary band. You didn't you didn't, you ignored the minister in relation to the derogations. How many derogations from the Code of Practice under the aegis of the department did you get? Was it just that for those years, or was it for more than those years?
The derogation was for the years that you have outlined. The organisation did receive a letter from the Minister in May of last year, which removed the derogation.
Can I just maybe just restate? Okay. Note 10 of the accounts, it states that it did not comply with the Minister's request to make the disclosure in the 2021 financial statements. It then, you know, so why was that the case? Like the Minister, it seems like you're, you know, the amount of money that comes from the Department of Agriculture, you would be paying very serious attention to that, to the Minister's request. Why did you do that?
I became Chief Executive Deputy in June of 2022, 1 year ago today, and in the financial statements for 2022, which have not yet been audited, all of the relevant disclosures have been made.
Can I just say, when you become when you've taken up that position, you presumably take responsibility for what happened before, because the other person's not here to answer. Did you make an inquiry as to why that happened? Can you just give me fairly short answers, because I have very limited time?
When we received the correspondence, the letter from the Minister advising us that he was lifting the derogation, and clearly the implications of that were that the financial statements in front of us, it was his wish that they would contain the relevant disclosures. It placed us in a difficult position legally because the contract of employment of the individual in question didn't contain any provisions providing for publication of his terms and conditions. And under GDPR and under the payment of wages legislation, individuals have a right of privacy, save where they have waived or contracted away that right.
Yeah, look, I mean, chief executive officers, you know, and right through the public service have, you know, have their salaries disclosed. Can I ask?
We asked to see the contract of employment for the chief executive. There actually wasn't a document produced to us. The only contract that was available was for his appointment as CFO previously with the Turf Club, and I think that was dated back to 1997.
So would this be unusual if you ask for something like that, not to then...
For an organisation not to have a contract of employment with its chief officer is certainly significant. With any employee, actually, is a very significant matter.
Okay. And then, I mean, obviously, then the Department of Agriculture, exactly what, you know, in terms of not abiding by the Minister's request, can I hear what you, what engagement you had with the board as a consequence of that?
Yes, so Deputy, you're right. So in 26th of May 2022, the Minister did write to IHRB removing the derogations. And so our understanding, my understanding is that in the interim period that there were, as highlighted there, it wasn't included in the CEO's contract and there was data protection privacy issues and so on, commercial sensitivities. So, while it didn't appear in the 2021 accounts, we have received the 2022 unaudited accounts, and they do appear in that.
Can I just say, the fact there was no contract, how can you say it was, you know, talk about a contract that didn't exist?
Yes, so I guess that's what we've been informed through HRI, who for governance over IHRB, and we were satisfied with that explanation and satisfied that it is appear now in the 2022 unaudited draft statements.
I've got to say the.
I suppose, Deputy, the significant point is that since there isn't a contract, then there wasn't an agreement not to disclose the figures.
Yes. So they could have been disclosed.
The other matter is that The department raised the issue with HRI about the 2 disclosures in May of 2022, but the accounts weren't actually signed off until December of 2022. So there was ample opportunity there to make the disclosure.
I think that speaks for it all, and indeed I'm reminded by the things that you've identified in your open statement and talk about integrity and all of that, and given this is the regulatory body, I think it certainly, and I know you post-date this, but it certainly doesn't align with you know, with how you would expect things to be conducted. You would not expect a minister to be ignored, and you would expect contracts to be in place at the very least. I would have thought that was self-evident.
If I could just address that contracts issue. Contracts are now in place with all current employees.
Yeah, I would hope they are, because I think there would be an obligation to do that. Can I ask how many other people applied for this early retirement or redundancy package?
There were 3 other individuals who departed under the package. They weren't the only applicants, but some of the applicants for redundancy, the applications were declined.
Yeah. Can I ask if they received more than the amount that was set out in the code, or was it only the CEO that received more than the amount, or a grant from another body?
No other contributions, or no contributions in relation to other people were made. The CEO's was the only one, as identified by the Controller and Auditor General, was the only one that exceeded the approved terms of the scheme, and it exceeded them by the amount of that independent contribution. And
was this something that was agreed as administrative at board level, the arrangement between the Turf Club and Irish Horse Racing Regulatory?
It would have to have been agreed at board level in both organisations, Deputy, for the transfer to have occurred.
Thank you.
Okay.
Thank you. Deputy James O'Connor, 10 minutes.
Thanks very much, Chairperson. And just from the outset, I just want to concur what Deputy Murphy was saying in relation to this being quite unusual that we wouldn't have the Chief Financial Officer with us today. And I just want to ask a couple of questions in relation to that. So just basically that you were only informed yesterday that he wasn't going to be in attendance, is that correct?
That's correct, Deputy.
Okay, and the reason cited for that absence was which?
The individual is on a voluntary period of leave as of yesterday, and hence couldn't appear here today.
Okay, and did they give us a reason behind their decision to do that?
I am not in a position to disclose any additional information in relation to any of this, unfortunately, at this time. And I do intend
I would beg to differ, because I think you are. It's not a criminal investigation. You know, you're going through it. You've taken a decision to do an external review, but you are very significantly funded by the taxpayer, and I don't think that's an illegitimate question to ask. So I'm going to ask you that question again. Did they give a reason why they decided to take voluntary leave at this time?
The individual concerned is currently on voluntary leave without prejudice to his position.
Did the individual give you reason for that decision?
Under the circumstances, unfortunately, I cannot say anything that would prejudice any investigation that might take place. And I recognise the Deputy's concerns, and I recognise that we are funded by the taxpayer, and I take that very seriously, and I take governance issues very seriously. And all of my conduct since I took up this role has aligned properly with governance.
Do you know what? I accept you're new. You're new, relatively new in your role, because your predecessor was there for quite some time, as we know, by what's emerged in relation to the early retirement deal. But I would state, you know, I'm a racing man, and I love horse racing and everything about the sport and the community within it. But I think a decision to go into this review process is going to cause prolonged damage I think it's unnecessary. I wish we could just get the answers here and now and get on with the job that needs to be done. So you're not in a position to answer why they took voluntary leave. Might you take that?
That's correct.
Okay. Just in relation to the details of Dennis Egan's early retirement and voluntary redundancy scheme, the sum was €384,870, and that payment was, I think, it was received in 2021. To my knowledge, I think that payment was about 58% larger, if I'm correct, through the CNAG, of what should have been paid out under the terms of the scheme. Can you understand why that is grossly unacceptable from a governance perspective and from a trust point of view as well? Irrespective of somebody's, longevity of service within the racing community, I think both of us can accept, having knowledge of the racing community, there are so many roles within it that are very well remunerated that people can move on to, perhaps after doing, work in organisations such as this one. That such a payment was not in the best interest of horse racing in Ireland, and was also, from a point of view of being 58% larger than what should have been paid out, damaging from a public relations point of view as well.
I'm satisfied that all of the decisions that were taken at that time by the various individuals were taken in good faith and were taken in what they perceived to be the best interests of the IHRB and of horse racing generally.
Really? So you think that's acceptable? 58% larger than what it was supposed to be?
Would I have done it like this? Arguably not. Was the governance around this entirely as it should have been? Clearly not. But in terms of the fundamentals of the decision that was taken at that time, I believe in the bona fides of the individuals that they took what they believed were the right decisions at that time for the organisation and for the sport.
Well, it would appear otherwise. And I take no pleasure here in having to make these points to you, but it's just flabbergasting really when you look at the figures that were paid out. And as I said, it's not a case that there's no roles to move on to after people work within organisations such as the IHRB. But I just personally I can't understand it. I just need to move on to the next line of questioning, because I just don't think we're going to get any satisfaction to our answers in relation to the Chief Financial Officer being absent. But I do want to ask you in relation to the motor running costs. So just in relation to the figures that were provided to us, the committee does note that there was a substantial increase in the IHRB's motor running costs during 2021. There was an explanation. Could you give us an explanation, really, in relation to why there was a €125,000 year-on-year increase? I just want to note as well that that was during the pandemic. There was very little, very little travel being done by anybody really, and I do know that racing did continue due to the hard work of some of the people in this room and indeed outside of it. But that just is a bit peculiar, and particularly due to the cost of diesel and petrol that year was quite low to my knowledge, or to my memory. But can you provide an explanation to that, please?
Our integrity expenses, and this is note 7 to the financial statements, our integrity expenses are very much geared to activity levels. And you're correct, Deputy, in that there was a COVID impact at that time, but the COVID impact in 2020 had been greater. So in 2021, we had almost a full card of race meetings. We had 395 race meetings, whereas we had significantly fewer the previous year. As a result, our officials, our vets, our security teams had to travel further to more race meetings, and therefore our motoring expenses, which are paid at no more than the revenue approved rates, would be higher, simply because more people had to go to work in more locations for more race meetings.
Okay, so that answers that, and I think that's satisfactory. Just in relation to, the question was asked as well by Deputy Murphy, but just in relation to the early retirement scheme that was introduced in May 2021, so you were saying to us there was 3 employees within the organisation that successfully applied for that. So that's correct, was it? 3
additional employees, Deputy. 4.
3 additional, okay. And originally then there was how many?
As I understand it, there were at least 2 other individual staff members who applied when the scheme was publicised. They applied for redundancy at that time, but when their applications were reviewed and evaluated, it was felt that the business case was stronger for retaining them than for releasing them.
Okay. So, okay, in relation to those that were accepted, so is it right in saying there was 3 people successfully received that?
Yes, it was an early retirement and voluntary or
yes,
voluntary
but I'm asking how many people?
So 3 people
3.
essentially went out on the
And did that include Mr. Regan,
side.
did it?
No, Deputy. 3 people who are not Mr. Regan took voluntary redundancy, whereas the CEO took early retirement, and the scheme encompassed both early retirement and voluntary redundancy.
Okay, and just in terms of the payments that were made, have you figures available on that, or could be provided to the committee?
The overall cost of the scheme is as set out in the accounts, and it came to, from memory, 746,000, I think, and that includes.
Say that again. 746,000.
46,000 from memory, Deputy. It is called out in the accounts.
Just want to clarify that. It's okay. Take a moment. It's in the interim while we're waiting for the answer. Can I just put it to the department?
I was correct, Deputy. I was correct. It's 746,000 was the overall cost of the scheme, encompassing the 4 individuals and including the additional payment to the departing CEO.
Okay. Just in relation to the Department of Agriculture, obviously we have the Assistant Secretary with us today, but I just want to ask in relation to the matter that has arisen that we're not able to discuss because we can't get the information on it. But I just want to get an insight. When was the department informed of this irregularity, and what has happened to try and address it sufficiently?
Yes, so Deputy, so we were informed, State Bodies Division were formed yesterday afternoon, that there was a matter which was financial in nature, and that caused some concerns. We were informed that there would be an independent review into the matter, and when we were informed about that, I informed both the Minister and SecGen in relation to the matter, but obviously that it would be subject to a review. I couldn't go into it in much detail based on the knowledge that I had at the time. And late last night I wrote to both HRI as a body with oversight for the IHRB, for the CEO, Mrs. Anid, and to Mr. O'Loughlin as the CEO of IHRB regarding the matter, asking that basically that the independent review be conducted as soon as possible and consider all matters.
Okay, thanks.
Thank you. Deputy Mark Postic.
Thank you, indeed, Chairperson. I'm going to just very quick, and Mr. O'Loughlin, I know that you find yourself in a very difficult situation on this. I just want to ask specifically about the voluntary leave, because of course it's analogous to some of the drip feed that we heard in the matter that we're dealing with later this afternoon. Was Mr. O'Brien, did he ask to take leave, or was he asked to take leave? It's a period of voluntary leave.
Correct.
That he has taken. Did he ask to take leave, or was he asked to take leave?
I would prefer not to answer that question, Deputy, because to do so could potentially prejudice an investigation or review that has not yet taken place. Because my answer to that might give rise to opinions being formed in relation to the matter.
Thank you. I understand that answer. To the department, it does sound to me like Mr. O'Loughlin, as soon as this issue was uncovered, acted very speedily, informed all of the relevant people. I want to ask you specifically about whether you are going to have input in terms of the terms of reference of this independent review, and whether you as a department are content that an independent review commissioned by the IHRB is sufficient in this issue. You have an insight on this issue that we unfortunately don't, or whether the department feels that they will need to take a stronger role themselves in terms of, again, as we have seen in the issue we'll be dealing with this afternoon, that the department and the minister decided that a full departmental external review was merited. Can you please give me your opinion on that?
So there's a couple of points there, Deputy. The first is in relation to the review itself. I think firstly we want it to be conducted with a matter of urgency, and we have, as a department, committed to conducting a review of the governance arrangements around the Horse and Greyhound Fund. And my opinion is that when we get this review itself, that this may feed into our terms of reference in that regard. But I would also point out to the fact that the governance of IHRB is in the first instance provided by HRI.
Okay. I'm not long on this committee, Chairperson, but we do see similar themes emerging from the different ones. A quick question to the CNAG regarding this contract of employment issue. So you asked for a contract of employment. I just want to clarify, is it that you weren't furnished with the document, or it was confirmed to you that such a document does not in fact exist?
Well, we certainly didn't receive it. We asked for it, and my understanding is that it doesn't exist. That we were furnished with a contract of employment relating to 1997, but that was with the Turf Club
CFO.
As CFO. And given the establishment of a company in 2018 to take on the regulatory role, I would have expected that anybody coming into a position in a new company would have received a new contract of employment.
So, Mr. O'Loughlin, I'll put the same question to you. Which is the case? Is it that the CNAG has asked for a document and has not been furnished it, or is it the case that such a document, this contract of employment, does not in fact exist?
Any document or any information sought by the CNAG has always been speedily provided to them. So any document that isn't provided has to be because either it doesn't exist or it isn't in our possession.
Okay, but then you have also told this committee that the request from the department, which essentially has been stonewalled to provide the full details of salary, etc., couldn't be furnished because of a contractual obligation not to disclose. How can you stand over that statement when you cannot provide the document?
What I said, Deputy, was that in the absence of a contractual provision waiving the right to privacy and consenting to the publication of the salary, the advice we received is that we would find ourselves in breach of data protection and privacy law and the Payment of Wages Act, because all employees have a right to privacy. So
can I ask the CNAG if you'd agree with that assessment?
Well, I obviously don't give legal opinions, but certainly the issue has arisen previously about disclosure of information, people who are paid out of the public purse. And my understanding is that there is an expectation that, and particularly with the more senior people, that information should be provided and can be provided.
And Mr. O'Loughlin, so am I right in saying that there's current discussions ongoing with the department about ceasing this ministerial derogation from the Code of Practice of Government and State Bodies, which in your opening statement said that your organisation was committed to? So are you currently still actually negotiating whether this disclosure will happen into the future or not?
No, the correspondence referred to related to the statements for 2021. But as I already outlined to the committee, and the colleagues in the Department of Agriculture have confirmed, the as yet unaudited financial statements for 2022 contain all of the relevant disclosures.
Okay. I just find it difficult to reconcile the stonewalling of a request from the department when so much of the funding is derived from the department and your statement and your opening statement that the IRHB abides by the underlying principles of good governance, accountability, transparency and probity, and we're just not we're not seeing that transparency at all. I do want to turn to that issue around the exit package, and so we have this contribution from the turf club, which doesn't appear as a contribution from the turf club but gets folded in to your general funding. Am I understanding that correctly? So it doesn't appear in that payment to the CEO, the exiting CEO, it's not detailed as a separate contribution from the turf club, is it?
In the payment to the CEO, there was a single sum of money put through the payroll system so as to ensure, which ensured that it was properly taxed. But the contribution from the Turf Club is called out in our accounts under other income.
But it's detailed as other income.
That's correct.
What further detail is provided?
There is no further detail provided in the accounts other than it is other income. And if it...
You regulate activities such as betting. Well, you regulate activities such as handicapping.
Handicapping, yes.
Which can have an impact on races. Would that be immediately and transparently, like Deputy O'Connor would have far more experience with racing than I would. I know very little about it. Would it be immediately evident to me were I to go in and place a bet on a race, as just your kind of rank and file punter going in to place a few bob on a race? Would it be immediately evident to me the impact of handicapping on the likely outcome of the race?
I know probably less about horse racing than you do. But
is it appropriate in that context to accept a payment of that nature and of that size when actually your regulatory function can have an impact on the outcome of races?
I'm struggling to see the link between handicapping and this, but notwithstanding that,
Okay.
I am not here to defend the governance arrangements that were in place at that time, and in particular around the transaction that we're discussing.
Okay. So the money, the contribution was folded in, recorded as other income with no other information, and then paid out as part of this exit package. Did that contribution then also cover other liabilities that will go with that? So that, you know, tax and social protection payment, employers, PRSI, the other things that, the other costs that come attendant with making an employee, payment to an employee?
Yes, which is why the figure under other income appears to be higher than the additional contribution to the retirement, because the difference is made up of employers' PRSI and related costs.
Okay.
And an issue did arise in relation to the employer's PRSI. I don't know if you want me to explain it or the CNAG to explain it.
We also asked for a copy of the correspondence or the agreement with the Turf Club in relation to the transfer, the amount of money being transferred. There isn't a document governing it.
Okay. So we don't really
I can't explain
line of
anything further about it. I mean, obviously there are calculations around the amount that was paid to the individual, but they're, if you like, a separate matter.
Okay. Just finally, and I have very few seconds remaining. So, Mr. O'Loughlin, yes, you are new in the role, but decisions made, particularly regarding the request coming in from the Minister for full disclosure of the details of a person's salary, I have to assume that that was discussed at a board level. So I have to assume then that that was subsequently minuted. Have you reviewed the minutes of the meetings that dealt with the Minister's correspondence?
I have not.
Would that not be of central importance, considering it was a discussion that predated your entry into the role, but was clearly going to be discussed today?
My understanding is the matter was raised at board level, but that decisions were not taken at board other than, no decisions I'm aware of was minuted at board, is as much as I can say.
That is extraordinary, that a decision relating to a correspondence from the Minister of the department that provides the preponderance of your funding, a decision was taken with respect to that correspondence and no decision was recorded at board level and minuted. I find that astonishing, if I'm quite honest.
Thank you.
Thank you, Chair.
Deputy Colin Burke.
Thank you very much, and thank you for being here before this morning, coming before us here this morning. First of all, can I just say to you that, you know, I fully understand where you're coming from in relation to the issue that's arisen over the last 48 hours, and I fully accept that the person involved that this matter needs to be dealt with before you can openly discuss it, and I fully understand your position on that. But can I go back to the issue in relation to the former CEO and why there was a need for a legal agreement, and then, you know, the whole structure of your organisation is set up under legislation, and a clause put into the agreement saying there couldn't be no information about the agreement could be disclosed. Surely when you get legal advice, or when the board gets legal advice, that legal advice should incorporate what you can and cannot disclose. Surely the legal advisors must have advised that this information could not be kept from the public domain.
All I know is that the matter was dealt with by solicitors at the time. Advice was taken, advice was followed, and the contract or agreement that you refer to, which is the termination agreement, did contain a fairly extensive non-disclosure clause.
I know, but what I'm saying to you is, you know, there was legislation in 2016 dealt with this whole formation, this whole setting up of this body, etc. You know, surely there was legal advice also obtained by the board that such a clause did not have any legal standing. Or else there was a situation where incorrect advice was given. So I'm just wondering, was it a case that proper legal advice was not furnished?
The board did take legal advice from a professional firm, a large firm. And
I know it's a large firm, but what I'm saying to you is that was part of that advice that, you know, we're now drafting agreement and there's going to be a non-disclosure clause. Surely there was an obligation, that large firm. I mean, in fairness to the people on the board and the people employed are not legal experts. Surely the legal advice would also have contained that this clause is technically not enforceable.
But the circumstances...
The CNAG just...
Yeah, I have a copy of the legal agreement. The non-disclosure agreement or clause is actually very standard, and it does provide for confidentiality unless and to the extent required by law or court order or otherwise. The matter is to be kept confidential. Therefore, IHRB had an obligation to give me the contract. I had to be able to see it because that's required by law. And, you know, I have then the right to report on the matter. I think there was a difficulty for IHRB in making disclosures, having signed that.
But the point I'm making is about whether or not the board got advice from their legal people that this document will actually, at the end of the day, end up being disclosed because of because of existing legislation.
I would think that anybody signing this should have been aware that there were circumstances.
No, my question is, were they made aware?
Well,
that's the question
yeah,
I'm asking.
whether the board.
That's why you pay lawyers, and that's why, you know, they have an obligation to disclose this. So I'm saying, you know, if we're using legal advisors, then all advice must be furnished, regardless of what the board wants or doesn't want. Then there must be legally advised what they can and cannot do.
I can't speak for the board in the matter, but certainly the parties who signed this agreement would have been aware of the nature of the non-disclosure agreement and the obligation on the organisation to disclose it in certain circumstances as required by law.
Yeah. Okay. Can I just go on about the 385?
Just to answer the Deputy's question, and I thank my colleagues in the CNAG for their intervention. The circumstances at the time the agreement was drafted, in fairness to the board, were such that the derogation from the minister remained in place. So the derogation from the minister from
no, but I'm not questioning about the board. I'm questioning about the legal advice the board got. That basically because you're covered under legislation, therefore the issue was that this document was going to end up being disclosed anyway at the end of the day.
And the Deputy is correct that our funding is state funding, and our activities are governed by legislation. But at the time the advice was given and was taken and acted on by the board, the derogation was in place. So one can only assume that against that backdrop, the advice was different than it might be were we to seek advice on the same issue today.
Can I just ask, in relation to 385,000 paid, did that include tax and social protection payments?
That was a gross figure.
That was a gross figure. So in other words, that's the full amount that was paid out.
But not all of it would have been received by the individual because it was all taxed through our payroll.
Yes, because he would have had to make the tax returns on it, okay? Can I just move on to something, another issue? The increased expenditure for forensic equine unit, can you explain why there has been an increase, such an increase?
Yeah, the equine forensic unit is the heading under which our equine anti-doping activity takes place, whether that be stable inspections or race day testing. And as the committee will be aware, we have stepped up our anti-doping activity very significantly over the last number of years. And as a result of the increased number of race meetings and the increased intensity of our testing activities due to the increase in the equine anti-doping strategy, then naturally the costs associated with that have increased.
Okay, and are there more people now employed in that area by you, or?
The costs are mostly lab costs, so we pay LGC laboratories. We're one of only 6 globally recognised horse racing reference laboratories. We pay them for every sample they test for us.
But do you feel that you need to employ more people in this particular area? Because obviously you talked about increased level of race meetings, all the rest of it. So is there a plan to increase it further, the number of people working in this area for you?
Yes, Deputy. As you recall, we had a review carried out by Dr. Craig Swan into our equine anti-doping programme. He made a number of recommendations, 18 in total, and we are in the process of implementing those. Some of them do have, as you're pointing out, a resource implication, increased testing, increased inspections of stables and so on. And to the extent that more resources are needed, plans are in place to implement those steps.
And in relation to stables inspected, on average, is it 1 in 10 stables are inspected every year? Is it 1 in 20? What kind of inspection level is currently in place?
In 2021, for example, we inspected 140 stables and we had licensed approximately 700. So the 1 in 5 chance of an inspection having occurred.
And that was 2021, but in say 2022, was that increased or was it at the same rate?
It should have increased and will continue to increase to the extent that resources allow. Because, as I mentioned earlier, it's important not just to take samples. So on a race day, we will always take a sample from a winner. We do pre-race testing on horses selected randomly. But testing horses in their yard, not on a race day, is a very effective way of detecting misuse of substances that might not still be in the horse's system on race day.
Okay, and random inspections, when you come into a stables, this is without any pre-warning, it's just arriving in and carrying out the inspection, is that correct?
That's correct. In fact, even our own team wouldn't know until the day of the inspection what premises they're going to be inspecting.
And, just in relation to the work to date, and you're talking about inspections, you're talking about 140 out of 700. Has there been any change in the, or has it been identified that there has been illegal substances used, or what is the position on that in relation to, say, the 140 stables that were inspected in 2021?
Yes, so samples were taken in total across all of those inspections. More than 1,000 samples were taken, and a number of those did return what we call an adverse analytical finding, meaning that we detected a prohibited substance and in any case where we detect a prohibited substance, then the matter is referred for disciplinary. So we have what we call a referral hearing, and we publish the outcome of those hearings.
And of the 1,000 samples that you took, what number were identified as being not in order?
These are what we call the out-of-competition tests, and from those tests, we had 12 adverse analytical findings in 2021.
And was that in relation to 12 different stables, or was it in relation to some of the samples taken from 1 or 2 stables?
That would be 12 individual samples, so from 12 horses.
But the number of stables involved? So you're talking about 140 stables, you talked about over 1,000 samples, but are the 12 samples from the one stable, or were they from a number of different stables?
We have a number of disciplinary cases still underway in which the findings have not yet been made, and some of the findings outlined there are still in process.
Okay, I fully understand.
So
Yeah.
I don't want to give information now that could potentially prejudice a
But
hearing
I know,
decision
but out
that
of the
hasn't yet
100,
been made.
okay, let's put it this way. Out of the 140 stables, how many stables did you find an adverse outcome?
That level of detail is not in our annual report, so any knowledge I have of which horses are involved and which stables they were in is because of my reading of disciplinary files, not all of which have concluded.
I fully understand that, but I think it's important as well that we need to have an idea, like, are we talking about one stable, are we talking about 3 or 4 stables, are we talking about 12 stables? That's what I want to try and find out of the 140.
We're not talking about 12 stables.
Okay.
We're
But
talking about a number that is lower than 12.
But we could be talking about 7 or 8.
It wouldn't be appropriate to play a guessing game.
And okay,
that's
can I
not my
just say,
intention
in
to do
relation
so.
to the adverse outcomes in 2021, have all those cases been dealt with now?
No. One of them we are still awaiting.
And from
a
the
decision.
time an adverse outcome is found and the time it's finally dealt with, what's the time period? Obviously, this is 2021, we're now 2 years on, so will we have those concluded by the end of this year, or will it take longer again?
We will certainly have preliminary findings by the end of this year, but the matter could potentially go to appeal. That would be out of our hands. But in the first
So
instance,
all the preliminary findings in relation to the 12 will be decided by the end of this year?
the hearing in the first instance will be concluded by the end of this year.
Okay, and in relation to the 12, how many preliminary findings have been finalised at this stage?
They all remain outstanding.
Why does it take that time period, like you're talking about?
Time Deputy.
Why does it take that period of time? You're talking about 2021?
I agree that the impression could well be taken that it takes that long to process a case, and it doesn't. All of the adverse analytical findings from 2022 have already been dealt with in hearing. We have had a number of adverse analytical findings in the first part of 2023. Many of those are ready to go to hearing. But occasionally we get a particularly complex case. And if it's a particularly complex case, no more, Chairman, than in any court of law, it can take longer to work its way through the system. So in parallel to large complex cases that may or may not be in the train, we also have the more simple, straightforward ones that we can process on an ongoing basis.
Okay, thank you very much.
Just in relation to the Deputy's question about the number of stables, is it more than 6 or less than 6? I'm trying to find why it would be that.
Fewer than 6,
Fewer
Chairman.
than 6.
I would ask your indulgence to leave it at that, because you can appreciate it's a small industry.
It's not a single stable, is it?
It's a very small industry, and we don't want to say anything that could cause difficulties for people who are not implicated in this.
And it's a very small number.
It's a very small industry,
And it's a very small number.
and there are not very many stables
Okay.
of scale.
Okay. Deputy Devlin, if you're ready to go.
Thank you very much. Thank you, Cathaoirleach, and thank you to our witnesses. Listening from the office earlier, I was beginning to think that there was a bit of competition for headlines today, because I was in shock, actually, at what I heard in terms of the unusual nature of the opening statement that we'd received, and then obviously the opening statement that was actually heard this morning in the committee room. And I do appreciate yourself, Mr. O'Loughlin, as Chief Executive Officer, coming today. It probably would have been easier for you had you just cancelled and rescheduled today. So from that perspective, I appreciate your attendance, given everything that seems to unfolded yesterday. But in saying that, and obviously in terms of what you have said already, and colleagues have asked many questions of it, how many people work in your financial department? 5. And of those levels, obviously there's the CFO who, for various reasons, can't be here today. Is there a deputy to the CFO?
We have a finance manager.
Okay. And would it have not been prudent to have somebody representing the finance department here today?
Because the issue all unfolded in such a short time frame, we weren't in a position to shuffle that quickly.
And you said that issues came to light as you were preparing for today. Is that correct?
That's exactly what I said.
And how long were you preparing for today, may I ask?
In terms of active preparation and trying to anticipate what questions could reasonably be asked by the committee, myself and my colleague and others sat down at 4 o'clock on Monday afternoon to ensure that we had answers to all questions that might reasonably be asked, and then reconvened on Tuesday morning at 10:30. And then the issue to which I've made reference, I became aware of that at 10:40. And
On Tuesday?
On Tuesday of this week. And that's where the preparatory meeting in the form it had taken ceased, and I moved to make the various notifications that we've discussed already.
Okay. So the time frame wasn't too long, actually. I was expecting you to say maybe a week ago or so. So given the fact that you started on Monday, today is Thursday, issues arose on the Tuesday morning. To my mind and to that time frame, I can't fathom why somebody from your financial department can't be here, because they're not here. Certain questions aren't being answered. And as you can appreciate, the Public Accounts Committee wanting answers about public finance, we can't get them today. So as you can appreciate from our perspective, it's quite frustrating to be asking questions either about the previous year's accounts or, as you say, some of the issues pertaining now to 2022. We can't get those answers. Can you appreciate why we find it frustrating?
If there are questions that I haven't answered this morning or haven't answered satisfactorily, I will absolutely furnish the committee with answers to those questions.
Well, actually, I'd take it a step further through the chair. I would say that given the fact that there are certain questions you can't answer today, and I understand why, you've outlined those, I would say that we might need to reconvene another meeting when you're in a position to do so, but not leaving it to notes to come back to this committee, or indeed wait for another calendar year to come by, because the serious nature of these issues in which you can't discuss today obviously lead us to believe, and given the fact that we are the Public Accounts Committee, we need to be assured that money is being spent wisely and is accounted for, and you can't allay any fears here today. In fact, the bombshell that's been dropped this morning has heightened awareness to issues within the organisation. Can you appreciate why?
I can fully appreciate the sentiments that the Deputy is expressing, and to describe it as a bombshell is not unreasonable in the circumstances. And since the matter came to my attention, I have made all of the disclosures that require to be made and notified all of the relevant people. And I've come in here today to answer questions to the fullest extent that they can be answered at this time, and I fully anticipate that there will be further questions at a point in time when those questions can be answered on foot of the review.
Okay, and as I said earlier, I appreciate the fact that you did come in, and a bombshell for us, I'm sure a bombshell for you and for the organisation as well. But in terms of, you said there's 5 members of staff in your finance department, and the head of that obviously can't be here today. How long has the CFO been in place?
I think 6 years,
Okay.
give or take a month or two.
Okay. And in terms of the revelation on Tuesday morning, was that something that you discovered during your preparation, or was that something that was brought to your attention during your preparation?
It's something that was disclosed to me during our preparation.
Okay. And as a result, and I'm aware that the department are aware, given the questions earlier today, but has the matter been referred to the relevant authorities external to yourself and external to the department, given the department only found out about this last night, I understand?
Disclosures have been made or are being made to all relevant authorities.
And those that are being made and have not yet been made, the time frame for doing so, I presume, given if it's as serious as you imply it might be, and the fact that you can't answer anything around the issue, how soon are you planning on ensuring that the relevant agencies and statutory authorities are informed?
Any disclosures that haven't already been made will be made. Any relevant disclosures will be made imminently, within no more than days. But as you can appreciate, there was only so much that could be done in the 24 hours available, so we prioritised our disclosures.
Okay. And if I can turn to Mr. Cronin as Head of Communication and Strategy, I have no doubt, it's my phone buzzing over here, I have no doubt your phone will be melting by this afternoon with questions for the organisation. And if not today, all the way through the next couple of days. How has this issue that arose, how has that been communicated to the organisation?
An email notification, because our workforce is distributed, and we've been discussing earlier how we have people all over the country, it's not feasible to convene a meeting, so an email went to all of our staff this morning which contained the same statement as I unfortunately had to include in the opening statement here today.
And in terms of that communication, is there any implication for any other staff member? How many staff do you have in total now at this present time?
We have 25 approximately in administration and then upwards of 100 race day officials.
Okay. But the core staff would be the 25, is that right?
That's correct.
Okay. And when you say all the staff are communicated to, was that 125 members or just the core staff?
The instruction was that the email would go to all of our staff today and would contain the same statement as was made here this morning.
Okay. But I'm just a bit perplexed. I asked the head of your communication section and the CEO responds. Are you concerned in terms of, from a legal perspective, of why no one else can make a statement about this matter? It has to come from yourself?
I think in the circumstances and given the situation, it's appropriate that the Chief Executive should take the lead on this.
Okay. And then can I turn to the department in terms of engagement? You know, obviously, to me, the hints in the name, the regulatory board having problems, who from the department wants to respond to the amount of engagement that goes on between the regulatory board and the department, and who oversees that relationship?
So just commenting in relation to that. So as you know, the Irish Horse Racing Regulatory Board was set up under legislation, set up in 2018.
Oh, I know all the history.
Just to give you a bit of context.
Well, I only have 25 seconds left, so
that.
let's...
So in terms of the context of that, in terms of the governance arrangements, HRI are the lead governance partner over IHRB, and we would regularly interact with HRI in that regard. And that's
how is regular, though? I need answers. Like, how is regular?
So So there's a number of different aspects to that. It would be, part of it would be the annual report that we get from the CNAG, of course, audited and so on. I'm in regular contact with Suzanne E., the CEO of HRI, in relation to matters, and that would include, but not always include, discussions on IHRB.
Okay, but again, regular. I mean, I attend here regularly, and that's once a week. Is that once a week, once a month?
No. So I suppose I went back through my diary and I checked the amount of times that since I've been in the job, I'd say I've been in contact with Suzanne on probably bi-weekly, twice a month, I'd say. Not always is IHRB discussed, but we would get regular reporting in relation to IHRB and other matters around it.
Okay. Thank you, Chair. And look, I just would ask then, through the Chair, that given the nature of the revelations today, that we as a committee would look to meet with the same officials again in the very short period of time, so we can establish more information around what's been unveiled today.
Absolutely. Deputy McAuliffe.
Yeah, thanks, Mr. Loughlin. Then, like Deputy Devlin, I was looking at my notes for the second half of today's PAC proceedings when I saw the opening statement, and I was surprised. And look, I actually have some empathy with your position. Clearly, something was discovered. You're taking particular action, and you don't want to do anything in a public manner, which would frustrate that. And you're doing that in the best interest of your organisation and the people and the industry. And I suppose we can only give you, as someone new to the position, we can only give you accept your bona fides on that. But I would say that does leave us with the option to reserve the right to recall you on the issues which we intended to ask, and I think you've effectively agreed to that already. Would that be true?
I'm grateful to the Deputy and appreciative of the empathy that you've expressed, and yes, obviously, at whatever time. And I note that Deputy Devlin said that I didn't seek to cancel or postpone today's meeting. Without being glib, Deputy, I didn't know that was an option.
It's a bad time to know now, isn't it?
You'd know you were new.
Probably would have done. And
everybody accepts the PAC invitation, and maybe it's the name is incorrect. But
Mr. Loughlin, I might just continue though the point. And there's one area that I would like to clarify. I've some experience of employment law, and the term voluntary leave is a very generic term. You might just explain to us, what does that mean when you say voluntary, that the person is on voluntary leave?
And given the Deputy's expertise in employment law, you'll appreciate that it is indeed a generic term, and it is a term that I've used here today advisedly.
Okay. The reason I say it is that, and I'm only using the words that you're contributing here. So if there's a disciplinary process, people can be suspended with pay and without pay, and all of those things. If there's a disciplinary process, people can be left in post. If people take annual leave, then that must be approved by their employer. There is no statutory voluntary leave. That doesn't exist.
I have taken and am acting on what I believe to be good legal advice.
It sounds more involuntary leave, if you don't mind me saying.
It would be my preference, obviously, that no inference be drawn in that regard, because we cannot say or do anything.
Look, I'm not going to seek to trip you up because for what I've just said, but I think you do need to reflect on that term voluntary leave, and perhaps on the next occasion that you might come back and explain it to us in further terms, even if there remains a potential legal claim or employment claim and so on. That term voluntary leave, I don't think you're best advised on that. It just isn't a term, and certainly not one I'm familiar with. Can I just to the HRI? I suppose some of the questions we'd hoped to ask were around the issue of the 58% payment. Can you just speak to us just in regards to your knowledge of that, and the approval or the funding mechanism and your role in the funding mechanism for IHRB?
Thank you, Deputy. So just to say that HRI had a voluntary early retirement scheme, that it did open up, and we invited the IHRB to be part of that. We had very strict terms and conditions of that, the eligibility and what would be the payments. And so we would receive some of requests for funding, some of which we rejected, some of which we approved, but they were all subject to the same assessment. Obviously, I can't talk about somebody else's employee, it's of a different organisation, but I can say that HRI were not aligned with any payment being made above the terms and conditions, and that was clearly communicated at a higher level than me and before I was in the role.
Help me understand that then. So HRI, let you use your own words, HRI extended an opportunity to IHB to be part of a voluntary severance round. What form did that take when you say extended the opportunity?
Well, we opened it up as part of a process. We wanted to make structural change in HRI, and we're very aware that the IHRB had, in 2020, conducted a review of its own structures. It wanted to modernise, it wanted to change, and we wanted to support them in transforming their organisation.
You wanted to have opportunities for people who were with the organisation a long time, an opportunity to leave in a voluntary manner.
If there was a business case around it and it made sense and it was better for the organisation.
That was the essence behind the reason why the voluntary scheme was there, was to allow, on a voluntary basis, people to leave the organisation.
If it suited the organisation.
If it suited the organisation, And so you agreed to fund that process?
Yes.
Okay. And I can understand how there might be a business case for doing that, even beyond pure finances. There may be other reasons for that.
Yeah.
So then I asked the question: was a specific application made to fund a severance payment above the terms of it?
There was not a separate request to us to fund an amount above the severance, the terms and conditions. No. We wouldn't have entertained.
Does the scheme allow for additional or side payments to the scheme?
No, it does not.
And would you be expected to be aware of any additional or side payments that would be made in addition to the scheme that's approved?
If it was to be funded by HRI, I would absolutely expect it to be communicated to us.
Surely from a funding perspective and a precedent perspective, you'd also expect to be made aware if additional payments were being made and which weren't being funded by HRI.
Yes, I would expect that, yes.
Yeah, and you weren't?
Not formally, no. Not formally. No.
When you say not formally?
Well, I wasn't in the role at the time,
yes.
But I understand maybe conversations were had, but clearly those that were involved were adamant that payment should not be made.
Okay, so there may have been...
There may have been, but I wasn't part of it.
You were party to it, yeah. But there may have been informal conversations between HRI and IHB as to whether it would be possible to make this additional payment, fund this additional payment.
Yes, I mean, at the end of the day, this payment was made out of a private club, nothing to do with HRI. We've no role in that private club, so we've no jurisdiction over that private club, and that matter and that decision that was taken by the board of the IHRB, which
but
is
the
independent
existence of
us.
additional payments in an excess of the approved scheme would undermine the overall scheme and could create precedent. It could create additional funding demands. Other employees that may come down the track afterwards may cite it as a precedent matter, and then there may be a position where it would have to be funded if it continued by custom and practice for a long period of time.
Well, I get your point. I understand where you're coming from. I think one of the things that we did with the department as well and with the IHRB is we strengthened our service level agreement around expectations, around things like that. So we've already put that into place, and I have agreement with the CEO of the IHRB that absolutely nothing like this will happen again, ever, on our watch, if you know what I mean.
Mr. Loughlin has informed us that a number of parties were informed that the CFO would not be present here today. Were you informed?
Yes, I was. Yeah,
okay.
Yeah.
I suppose that does put everybody in the room in a difficult situation. Do you have any comment on that?
Well, I suppose it's very disappointing what's happened. We will leave no stone unturned. I think Mr. O'Loughlin, in fairness to him, informed everybody immediately. He allowed me to choose who would do the independent review. It's not somebody that has any connection so far with the IHRB, so it is our internal auditors. So I will be very close to understanding what's gone on here with the issue. And to be honest with you, what I really need to do now is to support the IHRB through this awful time for them. So that will be my call to action on this.
And I suppose to some degree we're at a disadvantage because we don't know how awful it is, and we don't know what's coming down the track. The question then I'd say to you is that, does this pose a significant challenge for you to be able to secure votable public funds to continue to fund IHB into the future?
I think the main thing is we get to the bottom of the issue, get it resolved very, very quickly. And there's an urgency about this that, you know, it wasn't on my to-do list last week. It'll be the only thing on my list now for a couple of weeks till we really get this underway. So, look, the industry is such a wonderful industry.
Is there a possibility that this could include a criminal investigation?
I don't know. I don't know enough about it yet. What I would say is, this is an industry that everybody works damn hard for, including members of this committee and members of the Joint Oireachtas, our department. You know, it's an industry worth 2.5 billion. We have to protect it, and we have to get to the bottom of this quickly. So there is no lasting damage to either bodies. Is there a possibility the public funds might have been misappropriated? I don't believe so, from what I've heard so far.
Okay.
Yeah.
Thanks, Deputy. I think that there's nobody else. Okay.
I may have misspoken inadvertently in response to Deputy Devlin. He asked me about the 125 staff and whether the 25 staff in our office were the core staff. I should clarify that all of our staff are core staff.
Okay. I want to ask some further questions myself. I mean, just want to come back to the contract, or the lack of a contract. So Mr. Egan would have formerly worked for the Turf Club, and then he ended up being the CEO of IRHB. That's correct. Okay. And the nominations for the Turf Club or for the IRHB come from two sources: from the Turf Club and from the Steeplechase Committee, and then there are some independent people on that as well as.
That's right,
okay.
Deputy, yes.
Yeah, so he was operating on a contract that was from the Turf Club.
So it would appear.
Right. And the IRHB is a separate legal entity.
That's correct.
So that isn't a contract. If there's a new legal entity that hasn't provided
Would have been his employer.
Yeah. So
even though there wasn't a written contract, his legal employer was IHRB.
Yeah. So why would the very fact that he worked for the Turf Club and then went to be the CEO of the regulatory body, there was already. I mean, I think we had questions before in relation to the people who nominate onto it, and you know, how independent is it as a consequence of that. Anyway, and then for the Turf Club to pay a contribution, which I think is the word that you used. It's not a grant, it's not a loan, a contribution towards his exit. Really kind of undermines the whole separation, if you like. Maybe, Suzanne, you might like to comment on that in relation to, you know, I mean, you're trying to protect an industry, you're trying to protect the integrity of the industry, both from the point of view of, you know, things like doping, things like, you know, but the financial side of things. I mean, what would your view be of the muddying of the waters in relation to this?
Just going back, like I understand your very points on the contract. I understand now that's all resolved in the current environment that we're working in. I think that maybe they moved quicker on setting up the body than they were actually ready for at the time. I think the one good thing is, sorry, not the one good thing, one of the things they have really worked on is the quality of the board they now have in place. They have 2 independent people on that board. I think the governance, that alone will help me. Obviously, the issue that's happened is not something that I would like to see repeated.
So you're the primary one that has the engagement with the department.
Yeah.
That's where the money comes through. Would you have expected to see a contract of employment as almost one of the first things that you would have negotiated? The CEO is the person who's leading, who's driving. You would have expected to see terms and conditions, a contract put in place. Were you surprised that that wasn't?
Absolutely surprised, but the transparency with Mr. O'Loughlin in place, for example, his contract went through a review, with us, so that it was aligned to the normal CEO type contract. So I know that that's all been addressed now, but I agree that should not, it is unusual to find people not having contracts of employment with the right body.
Yes, like note number 6 in the accounts included, and it's been referred to earlier, under other income. There's a comparison between some of the things that we're trying to figure out in relation to the session we're having in the afternoon about things being opaque. Would that immediately jump out as a contribution from the Turf Club? If somebody was taking a set of accounts out, is this there to obscure, or is it there? You're supposed to disclose things in order that they're transparent. You can go through the accounts, you can see what's what. Other income seems to be a very opaque way of dealing with that.
I think they could have disclosed it differently, but the notes would have been approved as part of their audit review, I assume. But maybe the CNAG asked for a different disclosure. It didn't happen. I don't know. I wouldn't be involved in the preparation of their statutory accounts.
Maybe if I could ask the CNAG about it.
I think the Deputy makes a good point about, and it's something that we are constantly pushing for greater clarity in notes to accounts and so on. I really can't say anything further in relation to it.
Yeah. Can I just ask the on the scale of things, obviously protecting the industry, and obviously this is something that will come out probably over a period of time. In terms of what has been disclosed to you, is it the kind of disclosure that would be very damaging to the industry, or is it contained within the IRHB?
At this point, till the review is done, I don't know. My hope is that it isn't, and the sooner we know whether it is or not, it is what
Your
I'd be
first
about.
assessment of the scale.
It's just hard to say. It's more the nature than the scale for me. So that's the issue.
Right, okay. And in relation to the Department of Agriculture, what role will you have in relation to, or does it go through the IRHB in terms of your response to what has been disclosed to you?
Deputy, as you said, in the first instance, it will go through the HRI, but we have already written to them in terms of requesting that a full and comprehensive review takes place, and that we are kept informed regarding all matters regarding the review over the period of it. As I said, we've already also undertaken to do our own review of governance around the Horse and Greyhound Fund.
Right, okay.
And obviously, Chair, we'll be looking at it in the course of the audit of the 2022 financial statements until the review commissioned by IHRB is completed. We probably won't be completing the 2022 financial statements. But if there are any issues that need attention drawn I'll be pointing them out in the report.
Yeah, and where are we with the 2022? I mean,
We have the draft financial statements. Now, obviously, a statement on internal control will have to consider the issues that have arisen, or that have, I should say, come to light. And so that will all form part of our audit review. The fieldwork isn't underway yet, but it should be starting relatively soon.
right, okay. And just going back to the lack of any kind of documentation in relation to the turf club. I mean, nothing at all. I mean, was there a cheque written? Would that have been, how did the transaction happen?
Yeah, I don't know offhand, but I understand it was a single transfer. Yeah, as far as we're aware.
Right.
Sorry, I mean, we have the information, but I just don't have it to hand.
There isn't paperwork.
There isn't any paperwork that
it was a transaction without an explanation.
Yeah, exactly, and you see, this is the difficulty, and I think you've touched on it. The walls between the Turf Club and the IHRB. It's really important that everybody is very clear about it, and that the controls that operate to ensure that public business and the management of public money is kept separate from any other transactions. You also have the Turf Club and the Steeplechase Committee nominating the directors of the IHRB. Yeah. So it's really important that the control environment is very tight and very clear, so that we can give the assurance that's necessary around how public money has been used.
Yeah, like you kind of expect to see a regulator being kind of very independent, and in fact it would be, there are particular accounts that I think most of us on the Public Accounts Committee would pay particular attention to. You wouldn't be expecting the revenue commissioners, for example, not to have a clear audit opinion, for example. Regulatory bodies would fall very much into the same category, because they're the ones that are setting the standards for the people that they're regulating, and that's why this one is particularly important, and particularly important in an industry that has a lot of it's a very there's a very big impact on the economy, even in terms of the amount of money that's taken. And I'd be acutely aware of, just as a deputy from Kildare, just how what a big industry it is, and so regulating it is of critical importance to give the public some comfort, and that's why this is really kind of glaring. Are there any concerns in the Department of Agriculture about the fact that it continues to be people continue to be nominated by the Turf Club, and we could see the crossover here with the Turf Club making a contribution towards, an exit package for someone who they didn't employ? I mean.
So generally speaking, so obviously governance is of critical importance. You talked about public funds, and that's uppermost in our minds as well. So in terms of the board of IHRB, we're satisfied with the board, and I think it's important to note that, as we said already, as pointed out, there's 2 independent directors have been appointed, I think, on the 1st of January this year, and I think that will strengthen the board and provide assurances, I think, that governance going forward will be fit for purpose. I would also point out, and I think...
Would you not think it would be better if they weren't nominated by the 2? And they were nominated...
My own view, for what it's worth, is that you're talking about individuals that have a very good knowledge and experience of the sport itself, and I think that's required on any board, along with other skill sets. It's required,
but should it be dominant?
I think the fact that we've got 2 very strong independent directors is sufficient, in my opinion.
And in terms of the additional contribution that was made by the Turf Club, what was the department's view on that, and how was that communicated?
So just in relation, I just would point out as well, just in terms of the board of directors, the minister doesn't appoint the directors to the IHRB. In terms of your second question, in terms of when it was communicated and how it was communicated, in a conversation with the Secretary General and Chief Veterinary Officer, HRI informed us of the payment, And it was made clear to us that, first and foremost, that no public funds, either directly or indirectly, were used in relation to the additional payment. And subsequently then, on in the audited accounts that we received on the 23rd of December 2022, as we've talked about, it was noted as by the Controller and Auditor General there.
Was the Minister made aware of it?
Yeah, the Minister, so once we had the audited accounts from the CNAG, the Minister was made aware of it. And
what was the Minister's reaction?
As you can imagine, in terms of governance, quite concerned, and subsequently wrote a letter, obviously a very strong letter, to the IHRB, and our Sec Gen wrote to HRI in relation to it. I mean, we're dealing with a body that receives, I think, in around 90% of its funds through HRI from public funds. So governance and financial management controls are critical, and that's very much the Minister's view, and hence why he wrote to the IHRB to outline his concerns around this.
And what was the nature of the concerns that were expressed?
So effectively, and it was clear in this, is that the early retirement payment should have been limited to the maximum amount set out in the scheme.
Right. And about the contribution from the Turf Club, was there any reference to that, about the inappropriateness of it coming via that source, or the absence of a contract?
So you have to understand that we were informed by HRI that this did not come from public funds. So, but nonetheless concerned. And just to be clear, in the Minister's view and the Department's view, is this, and I think it's also IHRB's view, this shouldn't have happened.
Okay. Right. I think I think that concludes the business of this session. I'd like to thank the witnesses and the staff of the Irish Horse Racing Regulatory Board, the Horse Racing Ireland, and the Department of Agriculture, Food and the Marine for their work involved in preparing for today's meeting. We'd also like to thank the Controller and Auditor General and his staff for attending and assisting the committee today. Is it agreed that the clerk will seek any follow-up information and carry out any agreed actions arising from today's meeting? I'll agree that myself. Is it also agreed that we note and publish the public open statement and briefing provided for today's meeting? Agreed. I'd like to thank you, and the meeting is now suspended until 1:15, when we'll resume in private session before resuming in public session at 1:30 for our engagement with RTE and the Department of Tourism, Culture, Arts, Gaeltacht, Sport and the Media. Thank you.